I'm Brad Hull. I'm an attorney with Kevin Hickey Law Partners. This is a 2-minute lawyer. Today's topic is summons and service of process. So as you may know, generally when you begin a lawsuit, you file what's called a complaint. But the complaint doesn't really get the case going by itself. You'll need to also serve the other parties with the complaint and what's called a summons. The summons is a form that courts use that gives notice to the other party that they've been sued, that they have certain obligations with their response, such as the time they need to respond, where they need to respond to. The service of process is what we call giving legal and appropriate notice of the lawsuit. And this requires more than just simply handing the document to the other side and saying, hey, Judge, I handed them the document. You actually have to follow certain rules. And the thing I think about, and the example I give on this is that in the movie Pineapple Express, you might recall Seth Rogen's character plays a process server, and he goes and he knocks on the doors, and he'll be in costumes, and they'll answer it, and he'll say, you got served, and they'll get mad at him, kick him off the property. Well, that's one way to get service done, using a process server, somebody who's a certified process server. That's not the only way, though. And Arkansas Rule Civil Procedure number 4 lays out all the different ways that you can get appropriate service done. It's not a super simple rule. I counted today that there was 11 parts in it, over 20 subparts. There's definitely some complexities in it. Generally speaking, the way we get service done is either by a deputy with the sheriff's office, certified mail, or with a process server. Another option is a warning order, which will run in a paper, but there are certain procedural aspects you really need to be aware of before you do that. The key takeaway on this, though, is that there's rules you have to follow to get effective service, and you have to get effective service. If you don't, it can jeopardize your case going forward and certainly have negative effects in the future on it.